ladies and gentlemen, and it's our great pleasure to have Professor Goda, Professor Harramann. They went such a long way to here to give us the education for our intellectual property and the updated situation in Europe. Also today we have Senator Lin who would like to open in this conference for us. So let's welcome Senator Lin. 林委员，请帮我们开下场，请您上台跟我们讲讲。
主持人王教授两位来自德国的律师我们所长我们各位老师、各位同学大家好。虽然呢，今天来这边的同学不是很多但是我们王教授一直以来都认为这种东西是非常的重要未来在台湾整个在国际的这个商业竞争有关于这种专利专利的诉讼或是反垄断、反倾销的这种诉讼事实上是关系着我们国家未来的产业发展的重要的一个命脉。通常在国际上在这个诉讼的过程有的国外这个竞争，它是故意用恐吓，不见得我们台湾的厂商台湾的电子科技有侵权的行为，但是我们不了解就被他恐吓。那么这个恐吓的过程当中，他是用诉讼用诉讼，我们不晓得以为这还得了，一下去的话，这个美金1亿、2亿、3亿这样的一个赔偿金，甚至要涉及刑责，所以我们台湾很多的这种电子科技产业，在没有很清楚的一个状况之下在国际上，老实讲，这种诉讼反倾销、反垄断的诉讼是非常的惶恐所以未来我们台湾要往电子科技或是这个生物科技的发展的这种专利的国际上的专利诉讼的攻击防御反倾销、反垄断这一部分是很重要的。那么我们的同学也许对这方面在国际上还不是很清楚。那我们王教授他一直以来非常的重视这个区块所以不断的来邀请国际的一些著名的律师有关的学者来这边传授。那么这是老实讲这个是对整个国家的科技产业、生物科技产业电子科技产业未来台湾能不能在世界上继续生存继续活下去，是很重要的一个项目那么今天我们非常的荣幸有2位的这个国际级的专家也是律师也是这一方面的这个佼佼者来跟我们传授这一方面的一个知识我们除了感谢王教授，那么我们认为说这样的一个活动希望在我们云林县的这个大学里面能够引起同学的注意同学的关心跟共鸣这是黄老师用心良苦感谢2位教授，谢谢。
那我们现在请那个王贤达所长来帮我们讲几句话。
Professor Goda, Professor Harramann, we are very proud to see you at the Union University. 各位同学呢，大家好这个 Professor Goda 呢，是我们云科大材料所的这个客座教授我们学校正式聘他为客座教授。那他是这个世界中海局的这个智慧财产权的中海局委员那各位呢，如果你上网你 Google 呢，你搜寻他的名字的话，你会发现呢，有100多万笔以上那所以可见呢，他真的是在国上是一个非常非常重要的人物那所以今天呢就是我们真的非常非常高兴呢就是 他还有这个浩美呢能够来这边呢给我们一个这场演讲。那各位同学呢这个你应该好好把握这个时间呢来增广你的见闻那非常感谢呢王美心老师呢做这样的安排谢谢。
那我们请所长来颁证这个礼物给 Professor Harramann 和 Professor Boehmert. This is the gift for Professor Boehmert. For you. Yes. 拍照。
Thank you very much.
这个礼物要给这个 Professor Harramann. 那我们现在我们现在要请这个林委员来帮我们颁这个2011年这个专利布局海报比赛。请这个委员来帮我们颁奖给我们今年第1名的这个敏智同学。
在袋子里面。
奖状习敏俊同学参与2011年专利布局自产分析海报比赛荣获第1名。
谢谢Could we have a Professor Boehmert to give the award to our silver medal students who just win the 2011 pattern mapping poster competition? 请一位同学来代表。Give it to 他是要代表第3名上台的。Our student who just won the 2011 Paralympic competition poster.
Congratulations.
Today is our great honor. We will have Professor Harramann who will tell us about the protection measure against the justice enforcement of the patent. Preliminary injunction, product piracy, and criminal actions. So now, welcome Professor Harramann.
I think I can do without a microphone.
But it's okay, so
Okay. I'm a tall German with a loud voice, so probably, hopefully you can understand. Thank you, first of all, for welcoming us here in University. It's a big honor. Thank you also, Senator, for meeting us here especially. Today, I want to give you some short explanations about a specific aspect of patent litigation. Patent litigation is obviously complicated as such, and of course going into detail may become even more complicated, but I hope to make things easy and understandable for everybody. If somebody has a question, just raise your hand, don't be shy, and just ask your question. There is no stupid question, we only know stupid answers. Just to introduce myself, I'm a lawyer, so I do not have a technical background, but I do patent litigation. So I need from time to time some technical insight, because otherwise I would not understand the cases that I have to litigate before the court. And this is why in Germany, as in many other countries, patent litigation is always done by a patent attorney, like Professor Kodder, and a lawyer working in a team, just as an explanation why I'm here and what I'm doing here. My lecture today, as you can see, is about protection measures against unjustified enforcement of patents. This is something which is very important for one simple reason. Let's imagine that you are, after graduation, working in a company, a Taiwanese company. And usually that would be a high-tech company, for example. Let's say it's a company which is making USB sticks. I've got one here somewhere. Here. This is a USB stick. And your company is making USB sticks. And you wish to sell these items, of course, otherwise you wouldn't make money. And Europe is a good place to sell such items. What you have to do is, if you want to sell them, you have to advertise, you have to attend a trade exhibition, for example. And the place where you would usually start marketing is, for many reasons, Germany, because Germany is in the middle of Europe. Germany is the biggest economy in Europe. The biggest number of customers throughout all European countries is in Germany. So Germany would be the natural port of entry for any foreign company to come into Europe. This is why the biggest trade exhibitions, for example, in Europe, most important ones, like CeBIT for computers or IAA, the International Automotive Exhibition for car industry, are being held in Germany. The problem then is that, for the same reason, Germany has a very strict patent regime. You have already probably heard about this. The German patent system is very highly developed, and also the German patent litigation system is very highly developed. And this is why any foreign company which wants to enter the European market needs to know how to defend against other companies, maybe European companies, maybe US companies, or Chinese or whatever, companies who wish to protect their own market with just means or unjust means. And in many cases this is done with patents. So you must make sure that nobody is enforcing a patent against your product which may not be justified. And this is why you should pay attention to what I'm going to say. Just as an outline, in order to know how to defend, you first must know the danger, right? Otherwise you cannot defend yourself. So what you do is, or what I want to do is, I would first like to give you a short introduction into, first, the German practice on preliminary injunctive orders. This is something very specific for Germany. Second, the German border seizure or customs seizure regime, which is also quite special. Third, I need to tell you something about the dangers which lie in police raids, criminal action, based on patents. Once I have shown you the whole picture of dangerous things which can happen to you, I'm going to explain to you how to avoid them. First, by freedom to operate searches, and second, by using a protective memorandum. And as a conclusion from all of this, hopefully in the end we will have developed a suitable strategy how to really protect yourself against the unjustified enforcement of patents. So let's start with the first topic, which would be preliminary injunctive orders. This is something you need to know if you ever wish to enter with a product the European and especially the German market, because this is something very specific. Basically, you all know this, a patent owner can, if he finds an infringement or he believes that his patent is being infringed, he can go to court. He can file main court action, we call it Hauptsacheklage. It goes to the civil court and it's ordinary court proceedings. They are in Germany quite speedy. It can take between 8 to, let's say, 14 months. And once they've been completed, you have a first instance judgment, which can be enforced. The plaintiff has, if he wins, if he wants to enforce the judgment, he has to pay a security bond, and then he can, for example, stop the offering or the sale of the infringing item. He can request for damages, he can request for destruction of the infringing item. He can request for the withdrawal from the market. All very nice tools for the patent owner if he is successful. The problem is that I said already 8 to 14 months, depending on the court, depending on how complicated the case is. This can be, for the patent owner, from his perspective, can be too long. Because let's imagine you are now coming to the German CeBIT exhibition and you've got this brand new USB stick, complete new development, and you show it there. If I then sue you and it takes me 14 months to obtain a judgment to stop you from selling it, that might be too late, because until that time you've probably sold millions of them and I have suffered big losses. I don't want this. So the German system offers preliminary injunctive proceedings, summary proceedings, which are much quicker. You cannot get everything in summary proceedings. You cannot get damage compensation. You cannot get a destruction order. You can get, and this is the most important thing, at least in German patent litigation, you can get a cease and desist order. So you stop the infringer from offering the product, from selling it, from distributing, importing it. You can also obtain a so-called seizure order, which means that a bailiff, an officer from the civil court, goes to the owner of the product and just takes it away. If it's in preliminary injunction, then of course he will not keep it forever, but he will keep it until in main proceedings, which will follow, a decision has been made, and later they might be destroyed. You cannot request for damage compensation in preliminary proceedings, obviously, because they are only preliminary, and damage compensation would be something final, and destruction just the same. So what does the patent owner do? How can you obtain a preliminary injunctive order? You must understand how you get the preliminary injunction in order to understand how you can avoid it. First of all, you can file a request for a preliminary injunctive order basically with any locally competent IP code. We have a system of specialized IP codes in Germany. They are part of the district court, but not every district court will handle patent infringement cases. We have a limited number of 13 cases in Germany, 13 courts in Germany, district courts. They can handle patent infringement cases. And you may have heard this already. The most important court here is the District Court of Düsseldorf, taking about 80% of all the patent infringement cases in Germany. And if you imagine that about 80% of all the patent infringement cases in Europe go to German courts, then you can imagine how busy the District Court of Düsseldorf is. There's other courts, like for example Mannheim, who are also very important, number 2 in the ranking of German patent infringement courts. Some others are less important. So you can pick the locally competent court. The problem is, every court is locally competent because if you are on an exhibition, you tell the world, listen, I'm in Germany and I want to sell this to everybody. So basically you are offering it to the whole country. And this means that a cease and desist order can be granted by any court in Germany, even if you are standing in Hanover on the CeBIT exhibition, but the offer is addressed to the whole country. And of course, nowadays, everything is offered through the internet, and then it's directed to the whole country as well. So again, you can pick your court. You can do what we call forum shopping. If you want to obtain a cease and desist order against a patent infringer or somebody you believe is infringing your patent, you have to send him a prior warning. In main proceedings, just as a notice to the back of your mind, in main proceedings this is not necessary, and for many reasons it should rather be avoided in patent cases. But in preliminary proceedings, in summary proceedings, you usually need to send a prior warning to the defendant. The reason is very simple. I will explain it shortly. there's a possibility that the defendant himself cannot defend at all because the court will decide everything without ever listening to the defendant. And in order to avoid this, in order to minimize the danger and the risk for the defendant, the courts say you must give him prior warning at least. There is an exception. If you want to obtain a seizure order, you want really to take away stuff from the defendant, it doesn't make a lot of sense to send him prior warning because then, once you show up with the bailiff and want to take the stuff, probably it's all gone. So this is the only situation in which you do not have to send a prior warning. Prior warning can be on short notice. If there's a trade exhibition, you can walk on the exhibition booth of the infringer, tell them, listen, this item here you are exhibiting, this is infringing my patent. I want you to take it away. I want you not to show it. And if you don't do this, and here I have a cease and desist declaration, please sign. If you don't, I will be back very shortly with the bailiff and with a preliminary injunctive order, and then you will see what's coming of it. So it can be maybe 3-4 hours and that's it. The IP owner, what he needs to show, to demonstrate to the IP court if he wants to obtain a preliminary injunctive order, of course you must show that you are the owner of a granted German patent or of the German part of a granted European patent. This is the two types of patents that you can enforce in Germany. That's easy, usually should be. It can be difficult to show for the patent owner that his patent is valid. The court must have reason to assume that the patent which is going to be enforced is valid. A patent has been examined before grant. So basically there's an assumption that it should be valid, but everybody knows that not every granted patent finally turns out to be valid. So in many proceedings, the civil court has to assume that the patent is valid, and the defendant, if he wants to raise any issues about the validity of the patent, in many proceedings, he has to find nullity action, and then he can hope to be able to convince the civil court, the infringement court, to stay the infringement proceedings. In preliminary proceedings, this rule does not completely apply because the court will usually not even listen to the defendant. So the defendant cannot raise any doubts about the validity of the patent, and especially because this is all very quick and fast, he cannot file nullity action. So what you do, you have to show to the court that the patent is probably going to be valid. And the easiest way to show this is, you say, this patent is already old, it has been licensed successfully to several licensees, so obviously they believe the patent is valid, otherwise they wouldn't pay for it. Or you say this patent has already survived an opposition, or it has survived a nullity action. Then of course it's more or less bulletproof and you can enforce it. Obviously, you would also have to show that this is a clear case of infringement, nothing that you would really dispute a lot about. So you can clearly make a claim analysis, you can show all the features, and here you have your USB stick and you can show every feature of the claim is being realized. That, of course, if you cannot show this, you don't have a case. You must be able to show that the infringer, the defendant, the person that you are attacking or the company, is responsible for this infringement. Sometimes this is difficult because on the trade show there may be somebody who's just putting this on his desk and then it's easy. You show him, you see him, he's offering it, that's easy. But for example, in a case where this item is only offered in the internet, maybe by the Taiwanese company in Taiwan, and there's a German salesman standing there at the exhibition, sometimes it's not easy to show that this salesman, the one that you are really attacking, is responsible. Then you must show that the case is urgent. Urgency is a requirement which is not defined in the German law. The law only says the case must be urgent. It doesn't say when it is urgent. There's a general rule saying that the case is urgent if the plaintiff initiates court action within a period of 1 month after he has obtained full knowledge of all the facts of the case, the name and address of the infringer, and of course the samples so that he can analyze it, everything. Once he has secured this evidence without undue delay, then he has 1 month's time. After that, he cannot initiate preliminary proceedings anymore. Then he would have to initiate main court action. And finally, the case may not be too complicated. But this is a tricky rule because it depends on the court if it thinks the case is complicated or not. And the patent infringement courts in Germany, especially the courts of Düsseldorf and Mannheim, they are very experienced because they handle so many cases and they understand a lot about many different technologies. And I had cases for example, DVD technology, some essential patents, and they are really complicated. So we had to find like 70, 80 pages written of claim only to explain the patent, but still the court took these cases and they granted preliminary injunctive force. So how is the PI a preliminary injunction granted? Usually, in most of the cases, the court will render a decision after receiving the writ of claims within 48 hours. And in most cases, more than 80% without oral hearing and without even sending any notice to the defendant. So the court is deciding on the case and the court is rendering, for example, a cease and desist order and a seizure order against the defendant, and the defendant himself has no opportunity to say something to the case or to defend himself. The court may also reject this request, a PI request. Usually they don't do this immediately. What they do is, if they think that you don't have a case, the plaintiff doesn't have a case, the judge will call the lawyer and say, Dr. Harramann, I got your request, but honestly, why did you file this? It doesn't make any sense. Okay, what do I do? And get this. I withdraw the request, obviously, because I don't want to obtain a written decision against me. I withdraw it, maybe I refile it again in the next court, but that's a different story. In patent infringement cases, other than trademark infringement or copyright infringement, because patent infringement is a little bit more complicated, and the validity question is much more complicated than with a trademark, where everybody can see if a trademark is valid or not. In a patent infringement case, the civil courts tend to summon oral proceedings because they say this is going to be so important and it's going to be so expensive for the defendant to comply to a PI order. Most defendants would not simply take a PI order against them and simply say, oops, sorry. So they fight back anyway. And if the court knows already that a defense is going to come up, that an appeal is going to be filed, then the court would usually summon oral proceedings, but on very short notice. In cases on trade exhibitions, it can happen that the defendant, he got a warning letter maybe 3 days before the exhibition, and on the first day of the exhibition, he's being served with a summoning for oral proceedings next day. So he's got 1 day, he has to find a lawyer and a patent attorney, and he has to establish his defense. Everything must be ready for oral proceedings next day. That's not an easy job. Let's assume the court does grant a preliminary injunctive order. Then the court basically doesn't do anything. In the main proceedings, the court would serve the judgment to both parties, and the defendant, once he's been served, must comply. In PI proceedings, that's different. The court only sends a written decision to the plaintiff, and then it's up to the plaintiff to enforce this court ruling. He does it by ordering a bailiff to serve this court order to the defendant. And on a trade show, that's very easy. Basically, the lawyer takes the bailiff with him, and you walk to the exhibition booth of the infringer, and the bailiff says, I'm the bailiff, here's a court order, please sign. And if it's a seizure order, next sentence is, okay, show me your products, okay, here, USB stick, I take it. And if it's 5,000 USB sticks, it takes a truck and it's gone. So you have 1 month's time, 1 month's term to enforce it. If you don't enforce the PI order within this term, it's gone. But 1 month is a long time. The problem for the defendant is, even you are now standing there at your exhibition booth, nice USB stick, the bailiff is standing in front of you, he's not seizing the product, he just serves the order and says, okay, take it away. You say, no, no way. This is completely unjust, I've not been heard, the patent is not valid, I'm not infringing, I checked this all before, I want to defend myself and I'm not going to remove this because this is the only important exhibition for the next 5 years to come, and if I cannot show my product here, I'm not going to sell it anyway. In this case, the plaintiff can go to the court, he can ask for the fixing of the penalty, which can be up to 250,000 euro for each case of disobedience. And in case of repeated disobedience, it can be an arrest order. So the managing director or the person at the exhibition booth goes to jail. So you rather want to avoid this. Accordingly, you better comply to the request, because the bad thing is, even if you file an appeal, and upon your appeal, the court is lifting the injunction. They say, okay, you're right, you did not infringe. But because you did not obey to the court order before, so you say, I'm better than the judge, you still go to jail. Because this is a disobedience against the court order. It has nothing to do if you are wrong or right. It's just a disobedience, it's like a contempt of court, so you better obey. You can file an appeal, but first you have to obey the court order. If you file an appeal, the court will summon oral proceedings, sometimes very quickly. It's a good indication of what the court thinks about your appeal. If you file an appeal, a lengthy writ, and the court says, oops, hey, that's interesting. Tomorrow morning, oral proceedings, or let's say 3 days, 1 week, very fast. Then this is an indication that the court thinks there is something about the appeal, right? They think we may have to lift this preliminary injunction. If the court says, okay, oral proceedings in 8 weeks' time, you have already a very good indication that your appeal is not going to be successful. There will be oral proceedings, and in these oral proceedings, that is very important, the parties have to present all the evidence, whatever they have, all the defense arguments they wish to raise, must be raised in this oral hearing. You cannot say, oh, my witness is living in Alaska and it's hard for him to come here. You cannot say, oh, I'm just about to obtain an expert opinion on this USB stick. It's not ready, I'm going to file later. No. You must be there. Only the defense arguments that are present in this oral hearing will be considered by the court. After oral proceedings, the court, usually consisting of 3 judges, will in any case render a judgment. Sometimes, of course, they tell one of the parties, listen, don't go on with this. Either plaintiff, having considered this case, we can tell you we are going to lift the injunctive order anyway, so you may want to withdraw your request, or they say to the defendant, come on, your defense is not very promising, maybe you simply wish to accept the court order. But if this does not happen, then the court will issue a judgment. Of course, if in the judgment the PI order is being maintained, the defendant must continue to obey. There's one thing that you should know, if you are the defendant, and if this is coming on you like a big thundercloud, and you have the feeling that you cannot properly defend yourself, because you cannot, in the haste of the time, collect the necessary defense arguments and the necessary evidence, what you can do is you can force the plaintiff to initiate main proceedings. But still, the PI order will be in place for all that time. So you must obey, and then you can say, okay, I'm obeying now, but now I force the plaintiff to really go to ordinary main proceedings And there I will have a better chance to defend myself. Which is not a very nice perspective with a very short life product, of course. So, as a conclusion, preliminary injunctions are a very dangerous weapon in the hands of an IP owner, be it a patent, a trademark, a copyright. A preliminary injunctive order in the German system is very dangerous. They are easy to obtain. You can easily enforce them. It's not easy to appeal them because usually you don't have enough time to prepare your appeal. And usually they come at a very unwelcome time. For example, during trade exhibitions. The consequences are about the same as the consequences of a judgment after main proceedings. The problem is that it comes much quicker, and in many cases the battle is lost already for the defendant before he even knows that the war has started. Because everything has been decided already and the court sticks to its mind, so you cannot really properly defend. So, as a final conclusion to this first topic, don't worry, the others are short. You must, if you want to do business in Germany, you must try everything to avoid a preliminary injunctive order, because this is really going to hurt you if it happens. Topic 2, German customs seizure practice or border seizure practice. Most countries of the world do have a system of border seizure or customs seizure. So customs will seize if products are entering the country, they are checked, of course, for many reasons, tax and so on, and customs will also check for potential infringement of IP rights. The German system here is very strict, and German customs is really keen on seizing such IP infringing products. Any patent owner, as well as any trademark or copyright owner or design owner, can file a so-called general border seizure request. It goes to the central customs authorities, which are based in Munich. They have a central database which is accessible by all customs officers throughout the country. And it's very simple to file a general border seizure request. For example, let's say, again, it's a patent. You say, I'm the patent owner. This is my patent. You do not give more explanations about the patent, about the invention, why this is an invention and how it works and all that stuff. You just say, this is my patent. It's completely, for non-technically trained people, it's completely, I don't know, they don't understand the word. It could all be for German in Chinese, and the customs officer will not be able to understand it. And because this is so complicated, and because you cannot train all the customs officers how they can really detect a patent infringing USB stick and make a decision, oh, this is patent infringing and this is not. You do a very simple thing. You just have a white list and a black list. The white list is the list of the companies who are entitled to manufacture and import and distribute this item. You would not make a list of all the companies who are not infringing your patent, because that would be too long, but you say, okay, I know that this and that company, they are making use of this technology, but they have license, so they go free, don't seize their products. But here comes the blacklist. These are all the companies which I know already, being the patent owner, they make use of my patent, and they don't have a license for whatever reason. They don't want to, they think they don't have to, maybe they don't know they have to take a license, but they are the bad ones. And customs officer, if you see these products, then take them. So, now comes the container with, let's say, 40,000 of these, or I don't know, 100,000 USB sticks into Hamburg Harbor or Frankfurt Airport, and customs is inspecting this. Customs officers would check many things, but one thing is, they would check their database, and they say, okay, USB stick, let's check the central database. They find the blacklist, and they read, I don't know, what is it? I don't care. It's not from Taiwan. And they see, oh, blacklist. And they don't do anything more. They say, okay, blacklist, we take. Then they will do what we call a preliminary seizure. It's not taking forever. They take it, they put it into detention, and then they serve the importer with a notice. But watch out, the importer is usually not the manufacturer. The importer is usually the shipping agency or the freight agency or the airline. So they get a notice, and the patent owner or his representative, me for example, is getting this notice. If the importer does not object to the seizure within 10 working days, the seizure will automatically become final and the products will automatically be released. That's a bad thing. Especially if you are the manufacturer sitting back in Taiwan and it probably takes you 8 days to get notice from the shipping agent that something has happened, and then you have 2 days lost to ask the shipping agency, who has no interest at all in doing something about that, to help you and to oppose. So it's going to be tricky. If the importer does object to the seizure, then the ball is back in the field of the patent owner, and now he has 14 days, and during these 14 days he can obtain a preliminary injunctive order against the importer, or he can initiate main proceedings. So he files main court action. The bad thing then for the patent owner is if he only files main court action, which is basically easier because you don't have to convince the court with your first writ already, then the importer can pay a security bond and then the goods will be released. And you don't want this, of course, being the patent owner. So, if the importer does not meet this 14 days deadline, then the goods will automatically be released. Now the importer and the manufacturer are happy. So, of course, if your products are being seized by customs and you find, oops, I did not know about this patent, but obviously I'm infringing, and I think the patent is valid, then you should not start messing around with customs or with the patent owner, because this is going to be very expensive for you. Then you should start talking to the patent owner and say, oh, sorry, I did not know about this patent. Maybe we should talk about the license or something. But if you think it's not absolutely clear that this patent is being infringed, or you think this patent cannot be valid, then you must file an appeal, or you must oppose to the seizure. And if then the patent owner really initiates court action, you must fight it through. This was customs seizure. Third big danger in Germany, especially if it comes to trade exhibitions, is police raids. Professor Gotter and I, we have made some nasty experiences with police raids during trade exhibitions, representing Chinese, Taiwanese clients. And from these experiences, we have developed a strategy that I'm going to explain a little later. Basically, you all know this. I don't know about the law in Taiwan. To my knowledge, US is the only exception. In most legal systems, a willful patent infringement is a criminal act. In Germany, it definitely is. So basically, any patent owner can file a criminal complaint against everybody whom he suspects to be willfully infringing his patent. It is usually not the police which directly receive this complaint. It's usually the public prosecutor. Even the public prosecutor cannot, or usually, if it's not a very urgent case, would not on his own initiative then immediately initiate a police raid, a seizure raid, but in most cases, he has to go to the criminal judge, to the investigation judge, and obtain a search and seizure order. This is part of ordinary criminal investigations going on every day, everywhere, but usually not with regard to patents. So the requirements, and this is something you should read carefully. The criminal judge, the investigation judge, he will issue a search and seizure order if he has reasonable initial suspicion that a willful patent infringement has been committed or is about to be committed. But careful, this must only be a reasonable initial suspicion. The civil court only grants a seizure order and a cease and desist order if the court, after thorough consideration of all the facts, is convinced that there is a patent infringement. The criminal judge only needs a reasonable initial suspicion, which is, I think, much less than being convinced. So he needs reasonable initial suspicion. So he must believe that the patent infringement is being willfully committed. But this is easy because usually they say, okay, this is a big company and they should know about the patents which are around. So I being the judge, being the prosecutor, I cannot imagine that any company would really manufacture millions of USB sticks without even thinking about a patent which might be infringed. They have checked, or they should have checked. And this is sufficient. So it's a willful act. So the problem is, of course, the judge must also, of course, because you can only enforce a valid patent. The judge and the public prosecutor must also believe that the patent is valid. Here comes the first problem. Most of them do not even know that this is a requirement because it's not in the law. It's something which is behind the law, but it doesn't. You cannot read it in the patent code that the patent can only be enforced if it is valid. So, in the end, you have to say there's a problem.